Welcome to the channel. If you're the first time joining, if you're returning date coming back, boy. Ooh, I'm telling. Man, I've been doing some digging, some research. Man, I found out some things. Man, these folks play so dirty. These folks play so dirty. So without further ado, let's just jump off into it, man, because we got a lot of ground to cover. We're gonna try to consolidate this and let's just run it. Let's go.
To me today, can a civil case lead to criminal charges? So you've been sued civilly, and it's over damages. Say you've been sued for fraud or bad business dealings or breach of contract. How might that lead to a criminal case? So far you haven't been charged criminally, but you see what happens in a lawsuit. There's what's called a discovery process. Each side has to give all of their documents in their possession that are relevant to the case. And you're also subject to what's called an examination for discoveries. Well, that's under oath. So during this process, it might uncover all sorts of evidence that incriminate you. And the other side can then go to the police. It becomes a public record. The police can discover it. And the police may feel there's reasonable probable grounds to charge you with a criminal offense. So yes, civil charges can lead to criminal charges, and it's a very dangerous thing. So whatever you disclose to the other side may become a public record, and you have to disclose everything. Those are the rules in a civil case. It's full discovery. Each side has to give the other side all their documents, and you're subject to discovery. So that discovery is an examination of discovery. And there's a problem with that too. You see, now you're under oath, so you may be making certain admissions. Now, for example, let's say you testify at your criminal trial and you say something inconsistent with what you said at the examination for discovery in the civil case. Well, the Crown can cross-examine you on that as long as it's not a criminal admission. It gets complicated, but it's hard to keep people's story straight, even whether you're lying or telling the truth. If you've testified once in a proceeding and 2 years later you're testifying in a criminal proceeding, it's very difficult for even the most truthful witness to get their story straight.
Okay, this is the OCGA, or Georgia Code, updated version 2024, and these are the miscellaneous offenses concerning public officers, right, and employees. There's a whole lot more under this category. All you have to do is go up here and click this tab, Title 45, and it'll bring you to this, and you can go through that. But what we're going to focus on is offenses involving public records, documents, and other items, right? So, with that one officer tampering with the open records request and their body camera footage, right? This is pretty much what it states here. If a public officer or other person shall steal, embezzle, alter, corrupt, withdraw, falsify, avoid any record, process, charter, gift, grant, conveyance, contact, shall knowingly and willfully take up, discharge, conceal of any issue, forfeiture, recognized, or for other forfeitures, or shall forge, deface, falsify any document. This is it right here. Falsify any document or instrument, recorded and registered acknowledgement or certificate, or shall alter, deface, falsify any minutes. That's like minute entries when it comes to court records, documents, books, or any proceeding whatever of the belonging to the public office, right? So that means within their control, within this state. That means the whole state. Anything y'all do, right? Anything they do. Or if a person shall cause a procurer of these offenses to be committed, pretty much somebody who helps, or to be any manner concerned therein, he shall be guilty of a felony, bro. That's an F on a report card, homie. And then upon conviction thereof shall be punished for imprisonment and labor in the penitentiary. You're going straight to the pen, homie, for not less than 2 years, nor more than 10. So, bro, at a minimum 2 years in prison in the penitentiary, and you're going straight to labor, bro. You're going straight to the sweatshop. You're gonna be stamping license plates and stuff. So look, so now, which is so crazy, there's a flip side to this. Check this out. You can read into it some more and stuff like that. I implore you to read this all in its full entirety. Now check this out. If the officer or employee had probable cause at the time of such arrest to be made of that person committing unlawful acts and relating to public documents, and the arrest, the detention were under reasonable circumstances. Pretty much, An officer employee causing arrest or detention of any person pursuant to this code shall not be held civilly liable for slander, malicious prosecution, false imprisonment, malicious arrest, assault and battery of a person, physical injury, mental suffering, or any suit damages arising on such arrest, whether such arrest takes place on a public property or after those close pursuit of those on the premises by such officer, provided that causing arrest. And then pretty much, bro, so pretty much what it's saying is, like, all right, so if they had, where's that? If they had probable cause to make an arrest, right, they can still go back and do this and not get charged for it. So that's crazy. This is crazy. And I'm like, bro, this is in the same, is this, am I reading this right? I mean, I could pretty comprehend pretty much. I found this, you know what I'm saying? So let's go to this evidence.
You can come back to my office, but you're going to turn the camera off if you come to my office.
What I got to come back there for?
Well, there's no body cam or no dash cam.
What? There's no body cam and no dash cam. But the officer, she definitely had her body cam on.
No, she didn't. I already checked. I wouldn't write it if she did.
Now look, she points right to her body cam. She was like, look, I'm recording you too. Only did you get caught lying on video and audio, but then you turn around and lie on an open records request and on a police report. You falsified a document. And not only that, the police chief and the officer, the responding officers on this report, and you said there was no body cam or no dash cam footage, and then it was presented later on. Bro, that's a conspiracy, and you committed a felony. And if the police chief's involved, don't you think he kind of told this person to do this, bro? Like, what? That's a felony all day long. And when it becomes a conspiracy, all it takes is 2 or more people to conspire to commit a crime. That's a conspiracy, and that's without evidence, bro. It could just be off statements alone. Trust me when I say this. So now the big question is, who do you bring this to? Right? If you have proof, blatant proof of a police officer on duty acting in the color or under the color of law, you know what I'm saying, which is pretty much officer or any state or city or any official operating within the scope of their duties, right? Actually, that's actually outside the scope of their duties, because when you start breaking the law, that's outside the scope. That's why that probable cause crap comes in. Commits a crime, they can be charged for it, right? Now, this is where it gets tricky at, right? Now, with the civil proceedings, if during that discovery process, the court, once it's on record and it becomes public record, and the people know that, hey, these individuals broke the law a couple of times during the process of violating the plaintiff's rights. Oh, it's going down, and then it's going to be a domino effect of a whole bunch of BS, bro. So let's continue. Mind you, right, this case just got remanded back from the federal court for lack of subject matter jurisdiction and some other things that was explained. So right after that, it got entered into the system with Henry County. The plaintiff went and filed a motion to transfer and amended the complaint. Remember, you can amend your complaint several times before it's entered into the judge, and the judge could review it and stuff like that. After that, you can only amend it one more time, and the defense has to agree to that amendment in the complaint. So now, at this point, but the judge that's presiding over this case can't even hear this motion until all the defendants are properly served that's in this case. So the summons was issued prior, right? But then they had the case remanded and removed. So now the summons was supposed to be entered in here, but remember, back over here, falsifying minute entries. Listen, some things took place with some of this stuff in here, and when I say they playing dirty, I'm not gonna get into detail, but there is proof. And like I said, when it comes down to the civil litigation part, bro, it'll all come out in the wash. Look over here in the city of Hampton and see what's going on with this case, right? And as you can see, there's several defendants over there. Summons and stuff like that has been issued. The waiver for process of service, But the thing is, this town, they don't, the mayor does not respond to anything, you know, or the insurance company, anything, bro, with this case. So the summons was entered in and served by the sheriff's department, right? And so right after that, the plaintiff filed a motion for costs and fees to be reimbursed because they sent off under this, I think it's F or 7. Okay. The cost will be imposed to the defendants under this section of subsection for failure to comply with requests for waived service of summons shall include a subsequently incurred with effective service, together with the cost includes a reasonable attorney fee and motion required to collect the cost. So the only way that the court can actually review this motion is when all of the defendants are properly served. Now check this out. All of a sudden start quitting. 2 defendants quit, bro, off the muscle. They probably, I don't know when they quit, but they quit. If you've been keeping up with the channel, the prosecutor that was over this case when it went to the state, she quit too. Why is everybody quitting? Why is everybody running? Where y'all going to? So they're stalling for time. They're doing every legal tactic to stall for time, and it's a lot. Think about it. If you are not an attorney and you gotta research and like double check and triple check and quadruple check and make sure that you're crossing your T's and dotting your I's and you got all your ducks in a row. It's and then you have to just survive everyday daily basis of just setups left and right. So what they're doing is just stalling for time. That's what the name of the game is. We're gonna stall for time until something else can happen in the process, because this plaintiff is an easy win. It is an easy win, and there's pretty much there's something they could do about it, and they've been trying. Trust me when I say this. So let's skip all this, right? Let's say, and you the people, you can do this too. You can request this information. You can make an open records request. You ain't gotta believe nothing I'm saying. You can make an open records request and get this same information. It is public record. That's what they don't want. Point you in the direction to go look, right? So with all the civil litigation stuff going on, right? And if this stuff becomes a part of discovery and is put out in a court and more things are presented. Now remember, the plaintiff is pro se, so they don't know what the plaintiff's gonna really do. You know what I'm saying? It'll just be bad. Right? And once it gets out there and gets into that courtroom setting, it's going to be all over the place. It's going to be a mess. It's going to be a bloodbath. And then people are just going to start telling each other. They're going to start snitching. They're going to start snitching. Now, what happens? And this is a doozy right here. What do you think would happen if the evidence was brought to the district attorney or the state attorney or county attorney for the county that these police departments work in? Do you think they would pursue it? Well, you know, that's a good question. And that will skip everything. All this, them stalling for time. Okay, screw it. Let's just beeline it straight to the prosecutor of that county, this whatever jurisdiction they're in, these police departments, the civil litigation is in, and go straight to the prosecutor and say, hey, look, here, boom, here goes the evidence. Go get him. You're not gonna get him? That means you're not doing your job. No, you're in trouble. I was just snitching. I'm just snitching. Just tell the people, hey, look what they doing. I went to the district attorney about some corrupt cops doing some underhanded stuff. They're playing with court documents. They're falsifying documents. They're lying. Messing with the records or anything like that in a U.S. court or any court, it's a felony too. A federal offense at that. Whoever feloniously steals, takes away, alters, or falsifies, or otherwise avoids record, writ, process, or other proceeding in a court of the United States, that means everywhere in the United States, whereby any judgment is reversed, made void, or does not take effect, keyword right here, does not take effect, or who acknowledges or procures to be acknowledged in any court, in any such court, any recognized bail or judgment in the name of any person not privy or consent to do the same, shall be fined under this title and imprisoned not more than 5 years or both. Yeah, right. And this is on a I don't want to say a small case, but let's say this case was serious, and let's say the plaintiff was in custody on some serious charges. Now, mind you, remember where it said probable cause. If they have probable cause to make an arrest, that means they can go back and do all this and can't be held liable for it. And if the plaintiff is isolated in custody and has no way to communicate with anybody in order to get the truth out there and try to fight for their freedom and show that these things were done wrong and a bunch of constitutional violations were done, that's it. That person would go to prison for however long they decide to send them for. And God forbid the person had a criminal history or hit. They're just going to just shoot them to the moon with time. They're going to give them eons. Yeah, eons. They're just going to make some stuff up.
This thing is bigger than Nino Brown. This is big business.
All right. Listen, you need to go back and look under that Title 45 or whatever and look into that. Yeah. And these are things they do on a regular basis to get away with it. But they never came across anybody who would actually do the research. I'm telling you, that research, reading is fundamental.
Butterfly in the sky, I can go twice as high. Take a look, it's in a book, a reading rainbow.
So now let me break something else down to you real quick, right? Let's say there's civil litigation. There's multiple entities involved, right? But it all happened in the same occurrence. I believe that the double jeopardy rule applies to this. Like if you file 3, 4, 5, 10 suits, whatever, right? But it all happened at the same time with all these different entities, right? You can't sue one and then the other back to back to back to back. You can join them all together as one. Now remember, if the plaintiff has substantial proof as a matter of law to file a summary judgment saying that he was acquitted of the charges, right, at trial, and because the defendant was found, they violated the defendant's rights by holding him past 48 hours without bringing him before a magistrate judge, that's two substantial grounds that there will be no trial. The only way that they'll have a trial is if somewhere in the complaint, which the plaintiff writes, right, that this issue should be had a trial because the plaintiff can't show proof. He has the burden of proof to show that this actually took place, right? And there goes your one last time to amend your complaint. If it's something that you feel is going to drag it out even more, you could just take that out. Okay, cool. We'll just take that little section out. Everything else you're hit on. Hit. There is no trial. Summary judgment, right? So now what these what these defendants are doing, they're stalling for time and doing every legal tactic that they can. And you got to think about it. If you got the city, 2 cities, the state, and the county, and it's crazy because the sheriff's office is the county, you know what I'm saying? It's all states. So you got to think of all these employees, they work. It's crazy, right? They're going to do everything in their power not to get in trouble. They're going to pull all the stops. They're going to get all the little jailhouse snitches, all these people that work for them, their family members, anybody that they can. Your friends, whoever, anybody that's close to you, you're going to get everybody involved.